Chapter 6, Intellectual Property, Part 2C, Sampling and Remixing. The learning outcomes include: address the impact of digital sampling and digital imaging on copyright issues, compare and contrast digital, audio, and visual remixing, explore how copyrights apply when doing a parody or satire, examine how providers are responsible for the publishing of infringing content on their websites. In response to the technology advances in the 1980s and 90s, several laws were passed. One of those is the Audio Home Recording Act, or AHRA, passed in 1992, which allowed corporations to begin to sell digital recording devices without fear of being sued for copyright infringement. Under AHRA, sellers of digital audio equipment pay a royalty fee to the Copyright Office. Then they cannot be sued for copyright infringement. Further, corporations may not sue individuals who make copies of their digital or analog content, but only for non-commercial use. For instance, you're allowed to make a backup copy of a DVD or software that you own. These are legitimate, non-infringing reasons to make a backup copy. In case something happens to your original, it's destroyed by fire or water or other accidents, or is damaged in some other way, then you can rely on the backup that you made. However, a shortcoming of the Act is that it only applies to devices with primary uses to copy sounds and music. The law explicitly excludes computers and computer users. In Napster's heyday, the Recording Industry Association of America, RIAA, which holds numerous copyrights for music and songs, decided to sue those with deep pockets, going after manufacturers under AHRA, alleging they were infringing. The courts quickly ruled that the AHRA did not apply because the infringing music was copied from a computer hard drive, which was not the subject of AHRA. In all fairness, in 1992, lawmakers did not have the foresight to know how the internet was going to cause a massive paradigm shift. The courts also ruled that space shifting was allowed, where you watch a recorded show at a different place than where it was originally recorded. So you recorded it at home and took it with you to watch on a business trip. Although the courts ruled that organizations providing the equipment to allow recording could not be held liable for infringement, the court stated that individuals could be sued because they were not covered under AHRA. Although RIAA aggressively pursued individual offenders, they received very bad publicity and stopped for all but the most egregious of violators. They enlisted the help of colleges, who began to limit student bandwidth and downloading to reduce potential university liability for contributory infringement. Many colleges, in fact, turned over to RIAA the number of names of students who had downloaded copyrighted material. Ultimately, the digital music industry underwent a significant paradigm shift, offering customers the opportunity to license a copy of a single song for around $1. From individual perspectives, it was almost as cheap and definitely legal to simply purchase a song rather than attempting to do something illegal. Had RIAA been aware of the shift, they could have pursued digital sales prior to losing the market to iTunes, Walmart, and Amazon. In fact, record sales declined as the RIAA continued to go after individuals and sought to block the ability of consumers to choose the music they purchased. Rather than shell out $15 to $20 for a new album with 15 songs, some of which were of no interest to the consumer, Napster and later digital licensing of individual songs provided the consumer with an option that they wanted at a fraction of the cost. And they no longer had to carry around CDs. They could access music online easily and securely and legally. More recently, a remixing culture has emerged. People have access to all sorts of genres of music from whatever time period they choose. In the past, you were limited to listening to whatever the local radio stations played. Consumers now had options, and they wanted to remix songs or melodies in new and inventive manners. With digital remixing, artists manipulate pre-recorded sounds to achieve a different goal, presented to an entirely different demographic group. While imaging refers to visual arts, sampling refers to a translation of analog to digital formats. With the new remix culture, millennials have begun to question the established schools of thought. If everyone is getting stuff for free online, is everyone guilty of infringement? Or should we change the rules to match consumer behavior and expectations? It's so easy to copy and transform music and books and movies, and people become immune to the negative consequences. It's almost like speeding down the highway. If everyone is doing it, it's at least socially acceptable, and perhaps the laws should be changed. That's the way that iTunes and others saw the future of music and other digital media, and they responded in a manner that blended consumer expectations with the need to compensate the copyright holder for their efforts. Audio remixing has resulted in several high-profile disputes between artists. With audio remixing, artists sometimes mix melodies from one song with vocals from another for a creative transformation of the original music. They believe that sampling a fair amount is acceptable. The question becomes, what is a fair amount? If we go back and ask our very busy, reasonable person, they would probably say they're not sure how much is fair, but they'll be able to tell when they see it. If the words or music are altered enough, it's probably okay. If it's a parody, it's almost always okay, with or without permission. Currently, the courts are working to establish precedents in the area, but the courts are slow and laws are outdated. Visual remixing has also emerged as an area that isn't completely addressed in the law. Visual remixing has always been completed to remove flaws from models and magazines and such, but it's never been so easy to Photoshop a picture online as it is now. With Photoshopping, people take a picture of a famous or not so famous person and then manipulate it and distribute it online. This type of remixing may violate the rights of the photographer to make derivative works. As we will examine in a few examples, our very busy, reasonable person has to determine if important and recognizable elements have been used in the derivative works. This goes to the concept of substantial similarity, which, if you remember, access plus substantial similarity equals infringing on a copyright. Fair use exceptions do apply in certain situations. If it's for education use or editorial comment, or if you get permission to use it, then you're not infringing. If you do a parody or a satire, you always have a fair use of the product. However, since the courts have not reached consensus of these issues across the world, or even across the U.S., you should always consult a lawyer for legal advice on whether you can use an image and under what circumstances. This is one of my favorite examples, Campbell versus Acuff Rose Music in 1994. Have you heard of Two Live Crew? I have to be honest, I hadn't heard of them until I learned about this case. They wrote a song called Pretty Woman and said it was a parody of Roy Orbison's iconic song, Pretty Woman. Two Live Crew copied the opening bass riff and the first line of the lyrics and then changed to a play on words. Prior to recording the song, Two Live Crew told Acuff Rose, the copyright holder, that they would credit them with ownership of the song and would pay a fee to use the song. Acuff Rose declined, and Two Live Crew made their parody anyway. Of course, Acuff Rose sued, saying that Two Live Crew infringed on their copyright. The district court heard the case and said that Two Live Crew's use was a fair use and granted them summary judgment. However, Acuff Rose appealed, and the Court of Appeals reversed the lower court's ruling, saying it was not a fair use. So Two Live Crew appealed to the Supreme Court. SCOTUS decided that a parody may claim fair use when using copyrighted material, particularly when they need to copy the original music and/or words to make the point of the parody. However, Two Live Crew only took a fair use of the original song and no more than needed. Interestingly enough, the Supreme Court said that whether it's in good taste or not is irrelevant. If you look at the original and the parodied song, you'll see that they're very different and likely appeal to a different group of people. AHRA argued that Two Live Crew's use of their song would dilute the value of the original. SCOTUS concluded that Two Live Crew did not take more than necessary from the original lyrics and that the new song would have little market effect on the original. In other words, people who wanted to listen to the original would continue to do so, and most of them would never even listen to Two Live Crew's version. Further, although Two Live Crew did indeed make money off of their song, they could still claim fair use. This was a new addition to the fair use exceptions. You may make money but still claim fair use. SCOTUS also found that, like a book review quoting the copyrighted material criticized, parody may or may not be fair use. So while parody is generally considered fair use, each case should be examined independently. This case more clearly outlined the bounds of parodies, which was generally considered exempt through the fair use exception. SCOTUS reversed the Court of Appeals and sent the case back for further proceedings. The two groups ultimately settled for an undisclosed amount of money, and Two Live Crew agreed to license the original work, which they had asked to do in the first place. You have absolutely got to watch Roy Orbison's version of Pretty Women and then compare it to Two Live Crew's version, both available at the YouTube links provided. It's understandable why AHRA didn't want to allow Two Live Crew to license or use the song with permission, but it's a hilarious example of how parodies almost always are allowed fair use. Politicians have never been reluctant to use songs without the permission of the artist. For instance, in the 2016 presidential race, then-candidate Donald Trump was asked by artists and copyright holders to quit using their song. The iconic "We Are the Champions" by Queen has been appropriated by many campaigns. I mean, the words are relevant to those trying to win a campaign. However, the copyright holder of the song said that they had, quote, never been asked by the Trump campaign for permission to use "We Are the Champions." They further said they were frustrated by the repeated unauthorized use of this song. The Rolling Stones said they have never given permission to the Trump campaign to use their songs and have requested that they cease all use immediately. Adele released a statement that said that she has not given permission for her music to be used for any political campaigning. REM was vocal with their criticism, with Mike Mills saying that he thought the orange clown will do anything for attention. I hate giving it to him. Further, the band asked that the media and the American voter should focus on the bigger picture and not allow grandstanding politicians to distract us from the pressing issues of the day. After George Harrison's song, "Here Comes the Sun," was used at the Republican National Convention, the family said that the unauthorized use of "Here Comes the Sun" is offensive and against the wishes of the George Harrison estate. Even Luciano Pavarotti's immediate family chimed in, saying that they would like to recall that the values of brotherhood and solidarity which Luciano Pavarotti expressed throughout the course of his artistic career are entirely incompatible with the worldview offered by the candidate Donald Trump. Trump isn't the only one who has been sued for using music without permission. Jib Jab makes satirical recordings of almost every presidential election. Although they argue fair use for satire, the copyright owners of "This Land Is Your Land" did not appreciate the humor and how they used the song. The two parties agreed that the song had been used without permission. Jib Jab argued that it was political satire and was therefore a fair use. During the course of the investigation, an attorney for Jib Jab noticed that, by mistake, the copyright for the song was not renewed in 1945. The courts found, therefore, that the song had moved to the public domain in 1973. The parties settled after that, and if I had to guess, I'm betting that Jib Jab paid some sort of licensing fee. If you get a chance, watch this short YouTube video that was made during the George Bush and John Kerry presidential campaigns. It makes fun of both sides, and I can appreciate that. We all know videos on YouTube often use potentially infringing copyrights. The copyright owners argue that posting on YouTube is a derivative right, and anyone using these copyrighted intellectual property must ask for permission first or claim a fair use exemption. Fair use is more difficult to claim if you post on YouTube and potentially make money. Again, if it's satire, it's likely to be a fair use exception. Otherwise, ask permission. The courts have not reached a consensus on this. So how do politicians get away with it so often? Candidates from all political leanings. The first way is by asking permission. Hillary Clinton, for instance, had the support of many musical artists and was allowed to use their music with their permission and sometimes their endorsement. If we went by the candidate backed by the most celebrities, Hillary Clinton won by a landslide. In fact, Donald Trump had trouble finding people to perform at his inaugural ball, but he still won the election. Most politicians follow a cease and desist order. If the copyright holder, often not the person who performed the song, gives them permission, that means that sometimes the copyright holder will allow a candidate to use a song without the permission of the original performer. And if copyright has been assigned over, the artist has no recourse. Make sure you know who has control of your copyrighted intellectual property. Occasionally, politicians are sued if they don't stop after being told to do so. The legal system is slow, clunky, and expensive, and judgments sometimes depend on where you're located. If, however, politicians use a song in a large convention center, the center likely has paid royalty fees for music played in the background. The politician should still check in advance and secure a license if needed. Let's look at another example. Here's Coolio, who is a successful rapper. In 1995, he released Gangsta's Paradise. Take a look at the YouTube video of this song. We're then going to compare it to a satire. Coolio's official music video has a very respectable 25 million views. Weird Al Yankovic is a very successful singer-songwriter, best known for his library of parodies of successful artists and their songs. You can take a look at some of his parodies in the YouTube link provided. Weird Al made a parody of Gangsta's Paradise and called it Amish Paradise. Amish Paradise has about 48 million views, almost twice as many as the original. When you watch Weird Al's parody, you can see why Coolio might not like it. For a little perspective, Weird Al asked Coolio for permission to use his song. Coolio said no. He also realized that even without permission, he couldn't stop Weird Al from making a parody of his song due to fair use. Years later, Coolio apologized to Weird Al. In his own words, he said, "Coolio, who the F do you think you are?" He did Michael Jackson. Michael Jackson didn't get mad. Parodies often make originals even more popular, and Coolio realized that in later years. Weird Al always asks for permission first and usually receives it. But if he doesn't receive it, he claims fair use. He's a prolific writer of parodies and has made a career of it. I'm sure he has a big pool of lawyers on standby as well. What about providers of social media websites where people post all sorts of copyrighted material without permission? YouTube, Facebook, Twitter, Instagram, Snapchat, etc. Should they be held responsible for copyright infringement of those who, for instance, post video that includes copyrighted material? The answer is it depends on the circumstances. If they respond to cease and desist orders by removing the infringing material, they are likely not to be contributory or vicarious infringers. That stands in stark contrast to Napster, who originally made it easier for people to infringe, encouraged them to do so, and facilitated the transfer of mostly music between users. Social media platforms today do have tools to try to prevent infringement, but again, it's the copyright holder's responsibility to protect his or her intellectual property. Should a company use copyrights for software and mobile apps? It depends. In general, companies should apply for all intellectual property protections that are available to them. Copyright may be a good addition to other intellectual property options like patents, trade secrets, and contracts, or you may choose a mix of them. Trade secrets won't work for mass merchandise material. There's no trade secret if the code is included with the purchased product and distributed to users. Often the best option is a click-wrap agreement, which works similar to a contract. We click I agree and promise to abide by the rules that we read, or more likely that we didn't read. A reasonable person, however, would read the entire document and consult an attorney with questions. But nobody reads the documents, even those of us who really should know better. Do you read the contracts before clicking I agree? It's something to think about. To summarize, copyright owners continue to battle those who use their intellectual property through lawsuits and court cases. It's become even more difficult to determine derivative works with the advent of digital media. Parodies and satires are almost always fair use, with or without permission, with or without good taste. The courts have established only a few limitations to using copyrights for satire or parody. For people to know what you're poking fun at, when you're poking fun at something else, they have to know what you're making fun of. Education and news commentary are almost always fair use as long as you take only what is necessary to make your point. Nobody will let you know when others are violating your intellectual property rights. Owners of IP rights must be vigilant to protect their copyrights. There are penalties to companies and/or individuals for those who infringe. Court cases, however, are cumbersome, expensive, and slow to resolve issues. Many suits are settled out of court for undisclosed amounts.